Hello and welcome to this edition of You and the Law. On You and the Law, we add law to the news. My name is Ekeminidim. I'm a legal practitioner, and I'm always glad to know that you're there keeping me company on this channel. A few days ago, the prime suspect in the murder of Ini Umoren was arraigned in court for the first time in Uyo, the capital of Akwa Ibom State. The charge was read over to him, and he pleaded guilty to the charge of murder. And after that, the matter was adjourned for continuation of the matter. A lot of questions have arisen as a result of what happened in court the last day. And in this edition of You and the Law, I am addressing a few of the questions I have read on social media for the enlightenment of the viewer out there. The first question is, having pleaded guilty to the charge, why did the judge not convict him straight away? Why did the judge have to adjourn the matter to another day? Here is the answer. The law does not allow the judge to convict and sentence an accused person who pleads guilty to a criminal charge just like that. Okay? So even when an accused person has pleaded guilty to the criminal charge, the law still has responsibility for the trial judge. The law requires that in spite of the plea of being guilty to the charge, the prosecution still has to present evidence to the court to enable the court to reach the best possible conclusion, that is judgment, on the matter. Remember that this is a capital offense, and the punishment in the event of conviction is a very serious one. And therefore, the law demands that every piece of evidence available at the disposal of the prosecution must be placed before the court to enable the judge to arrive at the judgment and the sentence in the matter as appropriate and as required by the law. So people shouldn't be surprised that the judge did not just go ahead to convict him straight away, but had to adjourn. The adjournment is to allow the prosecution to present the evidence before the court and give everything needed in law for the trial judge to be able to reach the best possible decision in the matter. There is another question. What then will happen in court on the next adjourned date? Will the sentence, will the accused person be sentenced by the court on the said date? And here is the answer. What will happen is that the prosecution, in this case, the Attorney General of Akwa Ibom State, or a representative from his office, will be in court that day and then present all materials available, all the pieces of evidence available, presented to the court. Everything that was obtained by the police in the course of investigation, the confessional statement, the clothes of the deceased, the result from the pathologist, the result, proof of evidence from the DSS that had taken over the matter, and every other material that is relevant to this case is going to be presented that day by the prosecution to the court. And when that is presented, that is to be presented through prosecution witnesses. In this case, the person that did the investigation for the DSS will have to come to court that day and then tender the report of what he did in the course of investigation, and then make himself available for cross-examination by lawyer on the other side, should the lawyer decide to cross-examine him. The same thing with the police officer who investigated the matter. He will have to be in court that day to present to the court the result of his investigation, the evidence gathered in the course of the investigation, and everything relevant to satisfy the court that truly this is the person that killed Ini Umoren. Every other person that had one or two things to do, but depending on the prosecution, that person will have to be called to the court that day to present his own evidence, the evidence of the investigation that he carried out. So that's basically what's going to happen in court that day. Now, it's going to take almost the same way that the full trial, the usual trial is done. That is, trial where the accused person had even denied committing the offense. So there will be evidence in chief, there will be cross-examination and re-examination if the counsel for the accused person so wishes. The counsel for the accused person can also decide to say, my lord, no cross-examination, in view of the fact that his client has already pleaded guilty to the charge. Now, the other question is, what is the punishment in this case? Does the punishment reduce because the accused person has pleaded guilty? And here is the answer. The punishment for murder is death by hanging or by firing squad. That's what is in the Nigerian legal system. And the fact that the accused person has pleaded guilty to the charge does not reduce or change that punishment. It is still the same. Having pleaded guilty to the charge, if the accused person is eventually found guilty by the court, the only sentence is death by hanging or death by firing squad. The fact of pleading does not in any way reduce the charge. Now, here is the other question. Will he be given an opportunity, to plead for mercy? And here is the answer. Yes, he will be given that opportunity. There is something called a locutus in criminal trial. And that means that after someone has been found guilty by the court allows him the opportunity to say something. Okay? In that process, the person can plead and say, my Lord, I am a first-time offender. This is the first time I have committed this kind of offense. Please have mercy on me. Pardon me. If you pardon me this time around, I'm not going to commit this offense again. And so on. He could say a lot of things. I am the only child of my parents. If I am sentenced to prison now, my parents will die. And so on and so on. Everything that someone that is in such situation is ready to say, the court is also ready to listen to him. So he will still be given an opportunity, to plead for mercy. But the final decision is that of the court. Now, the other question is, does the judge have the power to reduce the sentence in a capital offense? The answer is no. The judge has no power whatsoever to reduce the sentence in a capital offense. This is it. Once the law has fixed a punishment for an offense and does not give the judge the discretion to reduce the punishment, the judge will have no power to reduce the punishment. The judge is not a lawmaker. In murder trials, the punishment is death by hanging or death by firing squad, which I have already mentioned. And the judge is left with no discretion than to sentence the accused person as appropriate. That is, if the accused person is found guilty. Now, there is another question. Now that he has pleaded guilty, can he dispense with the services of a lawyer? Or does he still need a lawyer? Remember, he has pleaded guilty to the charge. Here is the answer. He still needs the services of a lawyer. This is murder trial, and it is mandatory for him to have a lawyer by his side in the court. A lawyer doing, offering legal services to him in the court throughout the trial, from the day of arraignment up to the trial, up to sentencing, up to the decision of the court and up to, sentencing. And if he doesn't have a lawyer in court, or if he doesn't have the money to hire the services of a lawyer, the judge that is trying the matter is under an obligation in law to appoint a lawyer to defend him pro bono, that is free of charge. So, if there is no lawyer in court to defend the accused person, in spite of the fact that he has pleaded guilty, if there is no lawyer to still be with him to the end of that journey, the matter cannot proceed. The judge has to wait until he is able to procure the services of a lawyer, or until the judge is able to appoint a lawyer who is willing to, render services, legal services to him in the court. There is another question. Can the accused person stay back in prison custody on the date of trial and just await the judgment of the court? Remember, he has pleaded guilty. So can he just stay back and just say, people should go to court, tell me whatever the court says, and I will abide by it? Here is the answer. No. Under the criminal legal system, every accused person must be present in court on every day of his trial up to the day of judgment. If he's not present in court, the judge cannot proceed to hear the matter. The law says he must be in court, he must be present, he must know what is going on in his case, and if he has anything to tell the court, he must be available in court to tell the court. So the accused person in this case, though he has pleaded guilty to the charge of murder, must be present in court on the next adjourned date, and must be present on any other date if this matter does not end on the next adjourned date. There is another question. Can his plea of guilt be used as a perimeter or basis to convict any other person charged alongside the accused person? Remember that the person that has pleaded guilty is charged to court together with his father. His father has not pleaded guilty to the charge of murder, but the son has pleaded guilty to the charge of murder. So can the plea of the son be used in also finding the father guilty? Here is the answer. The answer is no. Criminal liability under the laws of the Federal Republic of Nigeria is personal. It cannot be extended. And so the man that has pleaded guilty, that is his own plea. His plea cannot be used as the basis for the conviction of the man that has not pleaded guilty. There is yet another question. What will happen if his father, who has not pleaded guilty to the charge, what will happen to his father who has not pleaded guilty to the charge of murder? And here is the answer. His father has a right not to plead guilty to the charge of murder. If he is sure that he is not guilty, then he can maintain, he can remain at that and not rush in to plead guilty to the charge because the son has pleaded. But his trial will go on. It will take the whole hog of trial up to judgment. So the charge was read to him. He has pleaded not guilty. And then there will be trial, presentation of witnesses by the prosecution, presentation of documents by the prosecution. And then his father will have an opportunity to cross-examine the witnesses of the prosecution in a bid to show his innocence. Now, after all this has been done, he will be given an opportunity to defend himself separately, okay? And the judge will then make a decision as to whether he is guilty or whether he is not guilty. That's the size of this very episode of You and the Law. Do remember to continue watching You and the Law so that from time to time you can learn one or two things from the principles of law governing the Nigerian legal system. There is so much to learn on a daily basis. As a matter of fact, law is, something that is in everyday living. Every aspect of our living as citizens of the country is governed by one law or the other. Continue watching You and the Law to learn as much as you can from these principles of law. Thank you very much. Do remember to subscribe by clicking the red button just beneath the screen that you are watching so that from time to time notifications can be sent to you. I remain your host, Ekeminudim. Do have a blessed day.